All right, welcome back, everybody. It is time to get started with our afternoon presentations. Our first speaker this afternoon is EPJ Faculty Advisor, Professor Gerry W. Beyer. Professor Beyer joined the faculty of the Texas Tech University School of Law in June of 2005 as the first holder of the Governor Preston E. Smith Regents Professorship. He is the recipient of dozens of outstanding and distinguished faculty awards, including the Chancellor's Distinguished Teaching Award, which is the most prestigious university-wide teaching award at Texas Tech. As a state and nationally recognized expert in estate planning, Professor Beyer is a highly sought-after lecturer. Each year, he presents dozens of continuing legal education presentations for many state and local bar associations, universities, and civic groups. Just recently, Professor Beyer was named the Editor-in-Chief of the Real Estate, Probate, and Trust Law Reporter. Please join me in welcoming EPJ Faculty Advisor, Professor Gerry W. Beyer.
All right, good afternoon, everybody. It's good to see you and so glad that you could come. And again, I know I'm just echoing what many other people have said, but the Journal, Riley and Ashley and everybody else have just done a stunning job with our seminar. Now, I know that you're all sitting there and you're eating and everything, and that's just fine. And we know we're going to be looking at the cases in a minute, but before we do that, I want to tell you about something that Ashley didn't say that I once did. For about 10 years, I served on the exam commission for the Board of Legal Specialization for Estate Planning and Probate. So I drafted and graded about 1/4 of the specialization exams. Now, I haven't been on the board for a while, but I decided that I wanted to see what kind of questions they were asking nowadays. So I downloaded the home version of the NSA PRISM program so I would be able to access all sorts of stuff. So when I downloaded that program, I was able to get on the site, and I got 4 of the questions for the next specialization exam. And I'd like to ask them to you and see how you do. Here's the first one. In 2009, Colleen Burns was declared dead. Her family decided to donate her organs. Just as the doctors were ready to harvest those organs, she looked up and said, "Hey, stop!" And then, of course, what did she do? Sued. How much did she recover? Did she recover $10 million, $5 million, $1 million, or a mere $6,000? What do you think? Just shout out an answer. $6,000. That's all she got for that. All right. Second question. Scott Ensminger. He died on July 4th, 2013. Horrible way to spend the 4th of July. But he specified in his will that his pallbearers were to be of a specific professional football team because he wanted his team to let him down one more time. Now, what team was this? Cleveland Browns, Dallas Cowboys, Detroit Lions, or the New York Jets? What do you think? Right, Cleveland Browns is correct. Third question. On January 20th of last year, a woman, she was all set out in her coffin. They were about ready to close the lid and shove her in the ground. She woke up and spoke. What were her first words? Were they, WTF? Were they, I'm not dead yet? Hello there? Or, hey, I told you zombies were real. Which one was it? And it was, hello there. That was her words. And finally, in 2012, which one of the following songs is the most popular one played at funerals? Is it Stairway to Heaven? Is it Highway to Hell? Is it Unchained Melody, Over the Rainbow, or My Way? My Way, that is right. Now, although these questions aren't really from the specialization exam, they were all real questions, real people, and the actual correct answers in reality. Well, enough of that now. Now we have to try to look at some material that hopefully you can really use. And what we're going to do is look at Texas recent cases from 5 main areas: intestacy, wills, estate administration, trusts, and other estate planning areas. Now, we don't have time to cover the over 30 cases that are in your material. So what we're going to do is highlight the most important and most interesting. And as we discuss each case, I want you to pay attention to the moral, to the lesson that you learn, so you can gain something from what has happened to others to do a better job for your clients and to avoid litigation. So let's first talk about cases dealing with intestacy. You know, most years, there aren't any intestacy cases. Even though most people die intestate, they just don't seem to generate appellate litigation. But there was one this past year, in re Estate of Forrester out of San Antonio, dealing with a very interesting inheritance rights case, dealing with whether descendants of an adopted out child who predeceases the intestate would be able to inherit. So what happened here is we had an intestate who died with no close relatives, no spouse, no descendants, no parents, no siblings, no nieces or nephews. The sole heir appeared to be a great-nephew who claimed the entire estate. But a complication arose because this nephew had been adopted out of the family. And the argument was being made is that since this person was adopted out of the family, that as a great-nephew, that adopted out person's child would not be able to inherit from the biological relatives. And this argument was being made based on a very strict reading of the code where they had neglected to include the phrase, and his or her descendants, after they said that the adopted person retains the right to inherit from his or her natural parents. They didn't stick in the phrase, and their descendants. However, neither the trial court nor the appellate court thought this was a problem. And they said it was clear, when you read the statute as a whole, that the adopted person who was adopted out of the family was still supposed to remain in the biological family tree, and that their descendants would be able to take as well. Of course, remember, that only works if the person, the original person, was adopted as a minor. It would not work if they were adopted as an adult. So that's our one intestacy case. Now let's take a look at some cases dealing with wills, starting with the case dealing with will formalities. It is the in re estate of Pinkleton case out of Dallas. And what happened here is a dispute arose as to whether the pages of a properly executed will were replaced by different pages at a later time. In other words, there was an allegation of page substitution. And the appellate court agreed with the trial court that there just wasn't enough evidence to show that any pages had been taken in and out. But the lesson to learn from this case is how easy it would have been to have helped solve this problem if the will had followed if the attorney who wrote the will had followed one of the common practices that many of us follow, which is to have the testator and the witnesses do what? Initial every page. If that had been done in this case, there would have been no issue to litigate. All right. The next wills cases we want to look at. Now, this would be of particular interest to those of you still in law school, because both of these cases demonstrate the importance of that dreaded first-year property topic, estates and future interests, because these two cases were all based on those issues. The first is the Roberts case, where the fight is between whether the gift was outright or a fee simple determinable. So here's what happened. This is an El Paso case. The testatrix's will provided that if a named child beneficiary died without a descendant, the property devised to that child would pass to that child's siblings. Well, that specified child beneficiary did survive the testatrix, but then later died without having any descendants. And so the child's spouse says, that didn't matter. As soon as my husband survived, he got the property, and it doesn't matter. But the other people, the deceased child's siblings, they said, look, it said that the property would pass to his siblings if he died without descendants. And both the trial and appellate courts rejected that argument. They said the gift was outright. That condition if you die, then it goes to your siblings. That was if the beneficiary died before the testator, not after. So what you learn from this case is, although the result probably came out correctly, is that when you put those types of statements in a will, you have to be sure to make correct and careful temporal references, so there's no argument as to the time that you're talking about. The second case dealing with estate and future interest issues is the Netherton case out of San Antonio. In this case, the testator's will gave the beneficiary a remainder interest in certain property, and then says if the beneficiary predeceases the testator, then the property passes to somebody else. And what happened is the beneficiary survived the testator, but this remainder beneficiary did not survive the holder of the life estate. And so when the life estate owner died, a dispute arose between the beneficiary's estate, the heirs and beneficiaries of the beneficiary's estate, and the alternate named beneficiary. And again, both the trial and appellate courts were in agreement, saying it was part of the beneficiary's estate. They said that all they had to do is that remainder interest was an outright grant of the remainder interest, and that there was no condition that the holder of the remainder interest outlive the life tenant. All that was required is the holder of the remainder interest survive the testator, not the holder of the life estate. So again, this is probably the right result in the case, but if you do want to impose conditions like that, that the remainder beneficiary survive the life tenant, be sure to put express directions in the will. Now the next group of will cases we're going to look at deal with will contests. And in the past year, will contest cases were by far the #1 appeal type of cases. We don't have time to look at all of them, but we're going to look at several, especially two dealing with issues of lack of testamentary capacity. Now, in the first case, what happened is that the testator was suffering from dementia, Alzheimer's disease, and a closed head injury, all at the same time, and made the will. And the allegation was made, oh, that person certainly doesn't have capacity. There's at least 3 good grounds. But the court said, no. They said, no, look at the other testimony we have. We have the testimony of the attorney who wrote the will, the attorney who supervised the will execution ceremony, the 2 witnesses that were there during the will execution ceremony, and the notary. And all of them together were very much in agreement that the person had capacity, and the court said that that was sufficient evidence to show that the testator did have capacity. Now we contrast that with the Lee case out of Houston. Here's what happened. The testator was going through a very rapid deterioration in condition, and the testator wrote a will on December 1. And everybody agrees that the testator had full capacity on December 1. But as I said, the condition deteriorated rapidly, and the attorney was called in to write a new will. And the attorney wrote the new will and came back several times to visit the testator, and each time the attorney said, no way, there is lack of capacity, I am not doing this. Well, finally it was New Year's Eve, and he went by, and again he thought that the person didn't have capacity, but the fiancée, beneficiary of the new will, she said, just leave the will with me, and if he gains capacity, I'll have him sign it. Then all of a sudden, there was a New Year's Eve miracle. He regained capacity, signed the will, and died. And the issue was whether or not the person had capacity when they signed that New Year's Eve will, and the court said, no, there was plenty of evidence to show that there was lack of capacity when that occurred. All right. The next 2 cases that are will contest based, both really have similar set of facts and a similar lesson. They both deal with undue influence. And in both of these cases, what happened is there was tons of evidence showing that the testator was susceptible to undue influence. Lots of evidence that they were in a weakened physical condition, that maybe they were not mentally as strong as they could be. And everybody was bringing in evidence that, oh, this person had all these reasons why they were susceptible to undue influence. But the court said, you just can't show that they were susceptible. You have to show like somebody actually did something wrong. You've got to show that someone actually influenced the person, not just that they were capable of being influenced. And the court said in both of these cases that there was no evidence that anyone exerted any undue influence, only that the person was susceptible. And in both cases, then, the court rejected the claims that the wills were void for undue influence. So those are our will contest cases. Now we're going to look at some estate administration cases, dealing first with a case addressing some very basic jurisdictional issues that the people in the case must kind of have forgotten. It's the Haga case out of Houston. What we had here was a decedent who was a North Carolina resident at the time of death. And the beneficiary was successful in getting a court in North Carolina to admit the will to probate. That's great. Then the decedent's parents had a Texas probate court admit the will to probate. And the reason for that was the will dealt with Texas real property. And so they wanted a Texas court to figure out the correct application of the will to Texas land. And the beneficiary came in and said, no. You've got to do it under North Carolina law. North Carolina law will govern our Texas land. And the appellate court said, that's right. The appellate court said, no way. Land is governed by the law of the situs. And the fact that there was land in Texas certainly gave Texas courts jurisdiction, and we are to use our laws in figuring out how that will deals with Texas real property. Oh, now this is an interesting case here. The next administration case is the In re Estate of Allen case out of Eastland. Now what happened here is this married couple, they were married for 56 years. And then unfortunately, the husband died, and the wife was the sole beneficiary of the will, and she wanted to get the will probated. Then she went to some lawyer. And the lawyer said, you've got a choice of how to handle this estate. One, you could probate this as a muniment of title. That doesn't sound so bad. Or second, you could do a determination of heirship. If you got a will, you don't do a determination of heirship. But the attorney gave her the choice. And she said, well, which one can you do cheaper? And he said, I can do the determination of heirship cheaper. And so that's what he did. And he actually attached the will to the determination of heirship. I hereby swear a person died without a will, and clipped the will to it. Okay? And so everything was fine until later. When some of the kids, they wanted to start keeping livestock on her property and not paying her and everything. And there was all this dispute over all this land. And she said, it's all mine. I'm the sole heir. This was a situation where it's just their kids, so by intestacy, all the community property would go to the surviving spouse. But there was a big problem. What was this land? Separate property. Right. So by intestacy, how much did the kids own? 2/3 plus the remainder in the surviving spouse's life estate in the other third. So the kids really did have all sorts of rights to be there. They had a 2/3 outright fee simple interest in the land. And so what did she do? She went and found herself a different lawyer. And this lawyer said, oh boy, that first lawyer really messed up. We'll fix this. We'll probate the will as a muniment of title and get this other one all set aside. And you know what those kids said? They said, hey, Mom, you did what? You waited more than 4 years. You waited more than 4 years. And therefore, you need to prove that you weren't in default. And the court said, you bet she can prove that. She said, look, she's not a lawyer. She doesn't know what a muniment of title is from a determination of heirship. It's not her problem. She went to a lawyer. She followed the lawyer's advice. And as soon as she found out the original lawyer's advice was bad, what did she do? It was less than 1 month before she had filed the will for probate. And the court said that shows definitely that she was not in default. And therefore the will was admitted. Now, the next estate administration case is also a very interesting set of facts. It's the Pine case out of Houston. And it all started from a prior appellate court opinion. And in the prior appellate court opinion, the court said, this administratrix, she is unsuitable to serve as a matter of law. And she didn't like that. So she appealed. So she went up to the Supreme Court of Texas trying to get a petition of review. And the Supreme Court said, go away. And they did not grant her petition. And then finally the appellate court issued its mandate. Sounds pretty normal. But in the gap between the appellate court's opinion and the mandate, the trial judge just let the administratrix continue to serve. Just let her kept serving and conveying property away and doing all sorts of things. And when this was brought to this appellate court's attention, they said, no, everything that administratrix did is no good now. We're going to set aside those conveyances and those sales and all of that. That she acted at her own peril. If she was still taking all these actions in court, thinking that the opinion would be set aside, and it wasn't, that's just too bad. So what you learn is you have to be very careful about actions that are taken during the gap period in between when the appellate court opinion is issued and the mandate is actually issued. Because if something happens in the interim that conflicts with the result that actually happens, there's a good chance that stuff is going to be set aside. Now, the next cases that we want to look at deal with the removal of the personal representative. There are two cases. The first one is the In Re Estate of Arizona case. This is out of San Antonio. And in this case, the appellate court affirmed the trial court's refusal to remove the administrator for misapplication, because what he did, or she did, is that they didn't go to court first to ask permission in this dependent administration to do something that they should have asked for permission first if they had, as the judge said, read the probate code or estates code properly. So, but they realized later, oh man, I should have asked the court for permission. And so they went and they asked for ratification of what happened. And the court said, you know, you should have done it the other way, but that is definitely not strong enough grounds for removal because there's no evidence that you embezzled or did anything else evil. In another case, though, you get a very different result. This is the Kirkland case out of Dallas. The probate court removed the decedent's surviving spouse and accused her of gross mismanagement and misconduct. And the appellate court looked at the evidence and said, you bet, you got to get her out. Now, why would you have to get the surviving spouse out a lot of times? It's because the surviving spouse is in conflict with not the regular kids, but the stepkids. That's right, the stepkids. And she was real mad because what happened here is that there was an intestate death. And so half of the community property belonged now to the stepkids. And a good portion of the separate property belonged to the stepkids. And, of course, the stepmom was not very happy about that, and so she was not taking the proper steps to protect the stepchildren's rights. The next case is a situation that often happens. You see, after a person dies, sometimes even while they're maybe still alive, but after they die, maybe after the funeral when you're doing the visitation in their house, what do family members start doing in the house? They shop, right? They go shopping, and they start grabbing everything. Oh, Mom wanted me to have that. Grandma wanted me to have this. And they take all this stuff away, and that's what happened in this case. And when the administrator got appointed, she was an independent executrix. She said, hey, I got to get this stuff back. And so she filed a motion for a turnover. And she said, look, we have a provision. It used to be probate code 37. Now it's estates code. I didn't think I looked it up. It's estates code something else. Use the charts I prepared, and you can figure out what the other sections are. Anyways, and the other side said, no. You can't get any kind of turnover order because the only way to get a turnover order is if you are a judgment creditor under the Civil Practice and Remedies Code. And they came back and said, look, we're not making any claims that we're a creditor. We're not seeking a turnover under the Civil Practice and Remedies Code. We're just getting the property that the probate code says we are entitled to. Because once an administrator is appointed, they have a superior right to possess the entire estate as it existed on date of death. And the appellate court said, that is absolutely right. You can get an order based upon the probate code section. You don't have to go mess with any kind of civil practice and remedies code type of remedy. We now come to our last estate administration topic, and one that is probably near and dear to many of you. Collecting your fees. Yes. Now, in these two cases, the fees were denied. So these are lessons to learn, because you don't want to do these things and end up not getting your fee. The first is the Kirkland case out of Dallas. And what happened here is the attorney, the case went on. The probate court issued a final order. Times went by. And all of a sudden the attorney came back and said, oh, I want my fees. And the court said, no, you can't go back and get fees after there was a final order. That you can't do that. If you want to recover your attorney fees, you have to request them and get them awarded in a timely manner. You can't wait till the whole action is over and then Monday morning quarterback and go back and get your fees. So what you learned there, when do you ask for your fees? Initial complaint, initial answer. Always ask, what's the worst that can happen? The worst they'll do is say no, right? So always ask for your fees as early in the case as possible. Now in the next case, I think it's pretty obvious that the attorney shouldn't get any fees. The attorney fees should not be paid by the estate in this case. What happened here in the estate of Beyer case out of Amarillo, the son was appointed as the independent executor for mom's estate. But there was a daughter, a sister. And they were having a big fight, and so what the son did is said to his sister, the daughter, you know what you've been doing? You've been vulturing the property. You've been stealing property. You've been embezzling money from the estate. You took it when mom was alive. You took it when mom was dead. And then after this, there were long discovery proceedings and all sorts of stuff. And the son was removed as the executor, and the daughter was appointed in his place. The son was removed. Why was the son removed? Because he admitted that he fabricated the whole story about his sister. That there was no evidence. He just made it up. He had no basis for any claim that his sister had taken the property. And then you know what he had the audacity to ask for? He wanted $80,000 in attorney fees for defending the removal action that was caused by him making up the whole story that his sister had embezzled all that money. And the court said, no, you only get your attorney fees if they are in the best interest of the estate. And certainly defending a removal action based upon stories you made up in your own head is not something that is in the best interest of the estate. All right. As I said, that's our last estate administration case. So we move on to some interesting cases dealing with trusts. The first one we're going to look at is the In re Paschal case out of Waco. An interesting discovery type case. Now, I want you to think, why do you use inter vivos trusts? Why do you use trusts most of the time? One of the key reasons is privacy, to keep the property disposition record off the public record. And that's what happened here. And there was a will, and the will left the entire estate to the trustee of an inter vivos trust, a very simple pour-over type provision. Then, 7 years later, somebody started to dispute the validity of the will, and thus the property that passed under the will to the trust. And the people who were disputing it were first cousins twice removed. I mean, how many of you even would know your first cousin twice removed, right? Most of us wouldn't have a clue if they were sitting next to us. And they wanted to see the trust document. They said, we want to see, we went to court and we want to see the trust instrument. Basically, they want to see, like, if they can maybe get something. I don't know. And the appellate court said, the appellate court said yes. The appellate court said, yeah, sure, you're entitled to it because you have a contingent pecuniary interest in the estate. If you were successful in setting aside the will, and then you were actually successful in proving you are the intestate's heirs, then you might be able to get some of the property that is currently held in the trust. And therefore you have standing to see the document. So what you realize here is that sometimes even an inter vivos trust that you would think would be very private might end up being discoverable in unusual fact situations. All right. The time has come now. No, not for me to have a drink. But the time has come for us to look at perhaps the most important Texas case in the trust area this year. It was decided by none other than the Supreme Court of Texas. It is the Rachel versus Weiss case. And here's what happened. A beneficiary brought suit, said, hey, trustee, you have misappropriated trust property. You haven't rendered an accounting. I'm going to sue you. I want remedies. And the settlor had included a provision in the inter vivos trust requiring the beneficiaries to arbitrate. The settlor tried to make the beneficiaries arbitrate with the provision in the trust. And the trustee said, yeah, I want arbitration. I don't want to go to court. I want arbitration. And the trustee filed a motion to compel arbitration. The trial court, the intermediate appellate court said, go away. The only way you have to arbitrate is if you agree to it. You can't be forced into arbitrate. And they said, you learn in law school. A trust is what kind of legal relationship? It is a conveyance of property. What is it not? It is not a contract. It is not an agreement. You might call it the trust agreement, but it's not an agreement. It's a conveyance. It's not a contract. And you can't bind the beneficiaries to something they never agreed to. But it went up to the Texas Supreme Court, and they said, no problem at all. We can bind those beneficiaries. The Supreme Court of Texas held that a provision in a trust mandating arbitration is enforceable, and they had two reasons for saying so. First, they said that's what the settlor wanted. Okay, what if the settlor said, I want the beneficiary to cut off their right arm before they get any benefits? Would the court enforce that because that's what the settlor wanted? Anyway, so that was one reason. It was just because that's what the settlor wanted. And second, they said, we really do have agreement. We have what is called direct benefits estoppel. The beneficiary received property under the trust. And by receiving property under the trust, they are in effect agreeing to all of the trust's terms, including the arbitration provision. And they said, if a beneficiary doesn't like that arbitration provision, you know what they can do? They can disclaim. They don't have to take it. If they don't like it, they can just disclaim it. And the court basically said that it would be incongruent to allow a beneficiary to hold a trustee liable to the trustee's fiduciary duties and not bind the beneficiary to anything else that the settlor had put in the trust instrument. Now, that's a Supreme Court of Texas case, so that is the law. Now, let's have some comments on that. This was a trust case dealing with arbitration against a trustee. I don't see any reason why the court would hold any differently for an arbitration provision in a will. So it'll probably work for in a will as well, arbitrating disputes against the executor. Now, it is true that the beneficiaries could disclaim and therefore not be bound by the provision and not get any property under the trust. But if you represent beneficiaries, you know the only time they read the trust is when? When something goes wrong, they want more money. Right? They don't read the trust. If a trustee starts sending money to a beneficiary, does the beneficiary say, whoa, I'm not taking that $100,000 check you just sent me. No way. I got to go read that trust instrument first and see if there's an arbitration provision in there. That doesn't happen. But does that mean now, and I could see this happening, that trustees are going to be bound by fiduciary duties to tell their beneficiaries first? Here's some stuff from the trust, but first, you have to realize if you accept this money and then there's a dispute with me later on, you must arbitrate it and you have forfeited your ability to go to court. The Supreme Court of Texas also left open many unanswered questions, like what do we do if the beneficiaries are minors, as they often are in trusts? People are accepting the money for the minors, but the minors can't consent. Who knows? So how to handle minors, how to handle incompetent individuals. And then the fear that I see is that a lot of people are just going to start sticking arbitration provisions in their wills and trusts as part of boilerplate language. And so you're not going to really have the active consent and active desire of the testator or settlor that the court talked about. The next case we want to deal with is about a receivership. And what happened in the Elliott versus Weatherman case, this is a case out of Austin, After the settlors died, their 3 children became co-trustees. And of course, you know, when you got more than one co-trustee, you're going to have disputes between or among them, and that is exactly what happened. And the dispute got so hot and heavy that the trial court said, hey, we're just going to have a receiver swoop on in and take all the property, and then we can deal with it. And believe it or not, it was the breaching trustee that asked for the receiver, not the 2 supposedly innocent trustees. And the 2 innocent trustees, they appealed, and the appellate court reversed, and they said, hey, yes, it's true that we have full authority to appoint a receiver under the trust code, but there was no evidence here that there wasn't a proper remedy in law or equity otherwise. In other words, they reinforced the point that receivership is an extreme remedy. It's like the nuclear option. You don't pick that unless it is an absolute emergency or an imperative necessity. Now, we've looked at one high court case already, Texas Supreme Court. We're going to go higher now. We're not in Colorado, but we're going to look at cases from the United States Supreme Court. The first one is the Bullock versus Bank Champaign case, dealing with an interesting intersection of bankruptcy law and wills and trusts law. The settlor created a trust for his children and named one of the children as the trustee. Then the trustee went rampant, breaching fiduciary duties. He borrowed funds from the trust and all sorts of stuff. He did all sorts of mean, nasty things, but he didn't have any malicious motive. The court found. The lower court said he didn't mean it. He just didn't have good legal advice. He didn't know. And you know what he did? He repaid the stuff. He repaid it, but there was still a judgment against him for breach of duty. In other words, he did repay all the money he borrowed, but there was still a monetary judgment for breach of fiduciary duty. And the poor trustee, he went bankrupt. And he wanted to get this debt discharged in bankruptcy. And the Federal District Court and the 11th Circuit Court of Appeals said, you can't discharge that. The Bankruptcy Code says discharge is not available for fraud while acting in a fiduciary capacity. And it went up to the United States Supreme Court. And an amazing opinion, because all 9 justices agreed. Can you imagine this opinion I'm telling you about? You got everybody. You got the far left, you got the far right, you got the people in the middle. They probably don't even agree what day it is sometimes, and they all agreed here that the debt should be discharged. They all said, you bet, let him off. And they said when they read that statute for fraud, that fraud indicates what? An evil, they didn't use the word evil, that's my word, but they had an evil state of mind. And this dude, although he did all sorts of stuff wrong, he wasn't evil. And therefore, the debt was dischargeable. The court held, in the words of the court, that he must act involving knowledge of or gross recklessness in respect to the improper nature of the fiduciary behavior, and he did not have that. Well, that's the end of our trust cases. We now have a few other cases that we want to look at. And like I said, we have 2 Supreme Court cases, so we're going to now look right away at the next of these cases, which also has a kind of similar connection to the final case that we're going to be getting to in just a moment. This first case is the Hillman case. Again, it's a 2013 United States Supreme Court case. Here's what happened. The insured was married, and the insured named his wife as the beneficiary of a life insurance policy. That all sounds great. Then the insured said, I don't like you no more. And the insured divorced his wife and found some other person to marry, married that other person. Then he died, but he never got around to changing the beneficiary designation on his life insurance policy. So now after he's dead, we have 2 people fighting over those insurance proceeds. His current wife and the ex-wife. They both say they're entitled to the money. Now, Virginia, that's where this case was, just like Texas, has a nice statutory provision that says upon divorce, all beneficiary designations in favor of an ex-spouse on life insurance are void. But there was a significant problem here. This was a policy not governed by state law. This was a policy governed by federal law. And federal law don't care what the state law says about this automatic voiding upon divorce stuff. And the Supreme Court of Texas said, it's too bad, but we only follow our law, and our law says the proceeds go to the person who is named, and the fact that they are divorced, is just too bad for the current wife, but that's the way it goes. And so they ruled that the ex-wife was entitled to the proceeds because the beneficiary designation had not changed. So you learn from that from an estate planning perspective, and those of you that do family law, that when there's that divorce coming, whether it's pending or final, be sure you go change all the beneficiary designations, because you might have policies governed by the law of another state or maybe the federal government that does not automatically void these types of provisions upon divorce. And so that brings us to our last case. And our last case also has to do a little bit with divorce. It is the in re estate of Woods case out of Tyler. And what happened here is the decedent died. And then the decedent was cremated. So now we have a box of cremains. Okay? We got the ashes. And we have people fighting over who gets the ashes. We have the wife wants the ashes. And then we have the son wants the ashes. And the trial court said, okay, wife, son, we'll give them to the son. And I know some of you are thinking, that doesn't sound right. And the appellate court also said that. They said, that's not right, because in the Health and Safety Code, section 711.002, there's a priority order for where the cremains go, and or anything else dealing with the body disposition. And spouse is number one. Have priority over your kids. Now, you're probably wondering, what kind of nitwit trial judge gave it to the son over the spouse? And here's the reason why. They were in the midst of a bitter divorce. At the time the husband died, they were in the midst of this big divorce. The wife didn't want him while he was alive, so why would they want a box of ashes after he's dead? But the court said, this is what the statute says. So you learn there also that in the midst of going through a divorce, you got to change the estate plan as well. And not only all the financial documents, but all the health care documents and the body disposition documents if you want to trump the statutory order. So that brings us to the conclusion of our review of recent cases. I hope you found it helpful and you can use the things we talked about to do a better job for your clients and your practice.